Yes, welcome to the No State Project here, live from my YouTube channel, No State Project. And missed a Wednesday or so there, but I apologize for that. It could not be helped. But we're back here live from the fortified compound in Mesa, Arizona for an extra hour of Anarchy Radio, in addition to the 3-hour broadcast that we do on Saturday, which also streams on YouTube. Well, it didn't stream this Saturday on YouTube, but you know. I still got the audio up there. It was just a train wreck of issues on the Saturday broadcast, but so far so good. We're doing all right. Although there is a storm brewing, I'm actually going to be in town for this storm, which is nice. You know, when we get rain out here, it's not like living back on Long Island where it's a regular friggin' everyday occurrence over here. No, it's kind of cool, kind of neat. And so if it does storm out there, maybe I'll have the opportunity to go out into the garage and watch that. But if you want to join me on the big broadcast here today, which is brought to you, of course, by Don, Dan, and Bill. And if I'm not remembering a name, I do apologize for that. But I do appreciate the continued support that they give to the big broadcast, Anarchy Radio, right here on my YouTube channel. And if you want to join the big show, it is 218-632-9399, 218-632-9399. The passcode, of course, is 2020 with that pound sign or hashtag. You can also instant message me on Skype at FrankRizzo3. FrankRizzo3. So before we get to calls, there was I think his name was Hollister. I think it was a David Hollister, who is a prosecutor in Plumas County, California. And this is an appeal. And talk about just dishonesty. Well, he's a prosecutor, so we repeat ourselves here. You know, it's being redundant. If you say prosecutor, then most of the time you're dealing with somebody who's really, really dishonest, especially if they want a black robe, where they could be dishonest with even more immunity. Okay, so what Hollister wrote in this brief, if you could call it that. Wow. We've been accused, even though we're anarchists, we've been accused of being one of those sovereign citizen types or one of those freemen on land type. And this is the first time that I've seen a prosecutor be somewhat honest in that. Oh, he contradicts himself. There's no doubt he contradicts himself here. He first lays out that none of the, even though the appellant did not call himself a sovereign citizen, they did not use those arguments. Nonetheless, they are still similar. And one of the things he claims is using 100-year-old court obscure 100-year-old court citations that are marginally, if relevant at all, to the case at hand. Well, if you've got a case where your argument is about a corpus delicti has to be in every prosecution, they have to plead and prove the corpus delicti. If that's current law, if that's current for their proceedings, who gives a damn how old they are? And to say that they're obscure or not relevant, well, every criminal prosecution. Oh, and by the way, I didn't think that 1992 was 100 years ago. So, or 1995. So, yeah, it looks like somebody is copying and pasting there. And so what he does to kind of summarize the point of accusing someone of being a sovereign citizen while saying he didn't raise any of their arguments and never called himself that. All he did was, punch a hole in the prosecution's burden of proof. But in his summary, he really shows how dishonest he is. So what he says there is that all the courts have been almost uniformly against sovereign citizen arguments. They are uniformly against and have declared frivolous the position that someone just refuses to believe that any jurisdiction can apply to them. The refusal to believe that any jurisdiction can apply to them. Nowhere in the paperwork and nowhere at the trial was that mentioned. Every step of the way, as you know, we are always hitting them where they breathe. We're taking the foundational claim that sets the relevance for everything else. And we just want to know about the evidence, if any, that proves it's true, and the witnesses with personal knowledge, if any. This is not a matter of we go into court and we're saying, well, I don't believe that any jurisdiction can apply to me. No one's saying that. This is what you call in classic logic a straw man. You just create something that you can then defeat. So instead of addressing the actual argument, which is that the prosecution didn't meet their burden of proof, instead of addressing that and presenting the evidence, oh, if you don't think I presented evidence proving that a written instrument from 1879 applies to you just because you're physically in California, you're mistaken. Because if you look at this part of the record, he doesn't do that. What he does is he creates, or he copied and pasted, which is more than likely what happened, a false argument. Claims that's the one that the appellant is using, and then knocks it down by showing, well, the courts have been unanimous in saying that this is frivolous. Yeah, but like I used to say as a kid, what the hell does this have to do with the price of tea in China? Well, gosh, it's not connected at all. It's called a straw man. It's dishonest. So I don't think anything's going to happen to this lawyer. I mean, if they apply the ethical rules to this guy, that he's arguing something that's not based on fact, it's not based on reality. He's actually deliberately misrepresenting the appellant's position in order to prevail on the appeal. That's an ethical violation. I would say it's also a felony. It's obstruction of justice, because there's no way he's doing this innocently. He went through a whole trial with the appellant. He knows what the position is. Where is your evidence? Where is your evidence? And by the way, accusing us of obscure citations? Isn't that funny to turn around and start into, quote, 100-year-old court cases to try to settle the issue of jurisdiction? Oh, that's right, because quoting a 100-year-old opinion can settle an issue of fact today. And yes, jurisdiction, it's a question of law and fact. Yes, it is. Regardless of how much somebody wants to say to the contrary, it is. Someone's asking me, what are your thoughts of a habeas corpus in the context of a contempt charge? Oh, absolutely. I think that should be, everyone should have a habeas corpus petition ready to go in case they are held in contempt. If the judge doesn't have any evidence of jurisdiction before him and he holds someone in contempt, that goes right to the legality of the incarceration. And since you're physically in custody, habeas corpus would be appropriate. So, Tom from the Big D is saying Terry and Noel's case, the habeas was filed, and 42 days later before a decision, they were released. Yeah, unfortunately, there's not much we can do. There is no teeth to the laws that govern habeas corpus, that they're not supposed to sit on it for 42 days. I'm glad they got out. Failure to appear, jailing. Yeah, there is somebody that I'm working with right now. Unfortunately, they're on the East Coast. It was a failure to appear. What I was told, he was late. He was 15 minutes late. 15 minutes late, and he got held with a failure to appear charge, and they're holding him without bail. I'm hoping the public defender will at least file a habeas corpus for him so that he can get a bail hearing and get out, because it's a nonviolent offense. But we'll see what happens. Unfortunately, because there is a public defender, I think that even if somebody does it, because you can do a habeas corpus as the plaintiff on anyone's behalf who is being restrained in their liberty. And unfortunately, I think because there is a public defender that seems to be representing him at this time, I think it's in Georgia, then I don't think any of our habeas corpus petitions are going to go anywhere because he has the lawyer. But it's still probably worth doing. So, and jurisdiction is the power to act. That's what it is, the power to act and hear a certain type of case. And that jurisdiction is supposed to be by the Constitution. So I don't see any evidence that the Constitution applies to anybody. At least not the people that they're attacking by virtue of it. So we got a bunch of calls already. Again, if you want to join me on the big show, it's 218-632-9399, 218-632-9399. The passcode is 2020. So I'll put the cones on, and let's see what we got over here. Make sure that everything is unmuted so we don't start with any stupid tech issues. All right, we got Eric in Los Angeles. Welcome back to the show. Eric in LA. Do we have a tech issue already?
Hi, Mark, because I can't hear you.
You can't hear me?
I can hear you only if I put my YouTube video back on.
Okay, hold on.
Can you hear me through the
Yeah, I can hear you just fine. I think I may know what the problem is.
Hello? I'm going to mute and go back onto YouTube. Maybe you can try me again in 10 minutes.
Yeah, can you hear me now? Now we got nothing.
Are you there, Mark?
Yeah, I'm here. I'm going to mute you back up and see if this is a problem. It's across the board. Damn it. We have area code 303. You're live on the No State Project. What's your name? Where are you calling from? Okay. Obviously, I've got a tech issue. We're going to try this again. I wish I was recording on the other camera so we can mute. We could delete all this out. But we're going to try again. We're going to try Eric in Los Angeles. Can you hear me now?
Hi, can you hear me, Mark?
I can hear you.
Oh, great. How are you?
I'm doing well. I whatever the issue was, it seems to I seem to have taken care of it. So what's going on today, Eric?
So I had talked to you a couple months ago. I have a criminal misdemeanor for driving without a license, and I sent in the 3 pieces of paperwork: the Brady discovery, the judicial notice, and the demur. And I challenged jurisdiction right away the first time I ever appeared and didn't enter a plea. And then the court rejected stuff, even though they said go enter it downstairs, pick a date. I keep driving to Napa. They keep screwing around with me, but he finally heard the demur, and he basically just glanced through all of it and said, you know, there's a lot of stuff in here that is about other states. It's not even California, and it's federal stuff. And on top of that, you know, the injured party is the people. And he started just making up stuff, but he wouldn't even force the prosecutor to go through where's the valid claim and where's evidence that's on the record. And he just basically did all the prosecuting and talking for him. And I kept demanding evidence and objecting to him denying things. So he dismissed that with prejudice. And then he got the judicial notice and said, at this time, I'm going to deny this, but you could resubmit it at a later point.
And he was denying the demur, and he was overruling the demur, and he said you could submit it at a later date?
No, the demur, he said that's history. I can never resubmit it.
Okay.
He's just denying it. The prosecutors typed up like a 10-page response, just all this garbage about the essence of jurisdiction is the fact. I'd have to send it to you. There's too much garbage in there to sort through, but it was all hogwash.
Okay. What did he
say? Judicial notice.
Yeah. What did he say that you could refile later?
The judicial notice, he said I could refile. And then the Brady, I finally got that back, and I actually went to the CHP office, and they gave me a full Brady. And it's funny how the officer that cited me for driving without a license, she never mentioned in the police report or included that I handed her a valid New Hampshire driver's license. But she, I guess in her mind, she's making the argument that I was driving without a California license because she's saying that I live in Napa because I have a house in Napa that I rent. So she used that as the address because she said, what address in the state can I receive stuff at? And so I'm wondering, should I file a criminal misconduct complaint that she's withholding exculpatory evidence when I did a Brady request?
Well, you have to file for a Brady violation and sanction. You can file your Brady violation, a motion for Brady violations and sanctions. Yeah. As far as criminal, for, let's say, obstruction to justice, you can give it a shot. It's not going to go anywhere. No prosecutor is going to prosecute a cop for that. But the thing was with the judicial notice, this is why the role playing is very important. The judicial notice is to make it more difficult for the judge to deny or overrule, rather, the demur. So when he starts going through, and it sounds like you guys have dialogue on some of the points, let's say when it comes to corpus delicti, yes, there are other cases in there just to bolster the fact that corpus delicti is a universally recognized rule or principle. Okay, but there are California Supreme Court cases in the demur. It leads off with those on that section. And so we use the requesting for judicial notice to help make it more difficult for the judge to do what he did to you. So while you're going through the, well, objection, I have a motion for judicial notice, and I've given you the California Supreme Court cases to support my position and my request for judicial notice. Does every criminal prosecution require corpus delicti? Yes or no? And you've got that in the California Supreme Court cases. The only reason why in the demur federal cases are cited is there might not be a California equivalent, but obviously this United States Supreme Court, they could be talking about things that have no application to California, but that's not the case here. I have where it's talking about, let's say, for example, that the American court systems are adversarial. That absolutely applies to the California court system. So he's just making excuses for the prosecutor not to make a valid ruling, an honest ruling on a demur. That's all.
Yeah. So I had a couple more settlement hearings, and I wanted to object to everything. I watched a bunch of I don't know if you ever watched some of Rick stuff on object to everything because of Nisi Prius courts and don't speak. And then Carl Lentz, if you listen to a lot of his old stuff.
Oh boy.
Anyway, so I did
Wait a minute. What?
I didn't.
Wait, I can't believe this reared its ugly head again too. Let's just talk about the arguments. I don't care who's actually promoting them at this point. Wow. What is a Nisi Prius court?
It's a subservient court. It's like a court that's not of record. That isn't even. It's just not a valid court, and I guess it doesn't have a valid judge and all this.
How do you know that?
It's not a. What's that?
How do you know that what kind of court this is? This court in California is operating.
Every time I demanded the fake judge or the commissioner, let's call him, because that's what he is. I kept demanding him to tell me the nature and cause of the actions, and he wouldn't. And so I said, well, is this an admiralty or military tribunal court, or is it a common law court? Because those are the two granted to you under the Constitution. And he said, well, it's definitely not military tribunal. And this is all when we were discussing the demur. because he just wouldn't like accept anything on the demur. He just was kind of reading, glancing through, throwing everything into a basket. Where are you getting this stuff? This looks like stuff you're getting off the internet, Eric. And I said, let's not discuss where I'm getting it. Let's discuss the actual points at hand. And so when I kept, this was like a couple settlement hearings ago, I kept like pushing, what is the nature and cause? And then I'm asking him and he's saying, it's definitely not military tribunal. And I said, well, is it safe to assume then that it's a common law court? And he goes, yes, that is safe to assume it's a common law court. But then every other time any topic would come up, he goes, we're prosecuting you under the codes and statutes of California, and then under California Constitution and under the Constitution of the United States.
Yeah.
And then I ask him about his oath of office because I'm trying to get him on the hook that I have constitutional rights and common law procedure.
Oh, come on. No, come on, Eric. That none of that enters into this. Because first of all, a nisi prius court is just a court that tries questions of fact. It's really just a fancy phrase for trial court. And
okay.
you know, what's important here is what are they relying on, whatever they're calling it, common law or statutory jurisdiction, where decades ago they displaced the common law in most states, and they displaced the common law with just statute law. So there's nothing in the constitutions that I've read that says the courts are limited only to jurisdiction at common law. But I think the important thing here is taking what they are actually using against you. What is their actual claim of jurisdiction? And if you ask them, they'll tell you. But they're
so the thing I kept pushing, because he wouldn't even discuss the topic of there is facts and evidence that the laws apply, and he's like, it's right here in the complaint. The complaint is signed under penalty of perjury by the district attorney. And I'm like, I've never met this Monica lady. How does she have personal firsthand knowledge that these codes even apply to me, and that I actually was violating any codes if they even did apply? And then he would go to, well, right here, you have the officer's citation. And I'm like, the officer didn't sign it. He's like, yes, she did. I'm like, this isn't signed. Nothing's signed, and none of these people have personal firsthand knowledge.
But you see, Eric, you're making things more difficult for yourself, because you're making statements and you're taking a burden upon yourself that you have to prove that those things are true. When he says something that the evidence proven the Constitution is on the ticket, ask him what specifically on the ticket is proof that the Constitution applies because you're physically in California. And then if they answer you that you're physically in California, you can object. Well, you're just repeating the argument. How does that prove that a written instrument from 1879 applies to me? And that's a lot more effective than just trying to make assertions that they're never going to agree with you on.
So I did exactly what you said yesterday. You know, I was up there for another settlement hearing, he keeps calling them, and I had all these objections, like there's no injured or harmed party, there's no sworn verified complaint, there's no facts or evidence. You know, I went through the court computers. There is no facts and there is no evidence other than this bogus complaint with an unsigned citation. But I said to him, you know, exactly what you just said. And he, I forgot what you just said. Now I'm losing.
Well, I asked him what specifically on the ticket would prove that just because I'm in California, the Constitution applies.
Oh, yeah. Yeah. And so he said, because you were in the state of California when the officer showed up after the fact when nobody was driving. But I objected and said, I am not, and I was not in the state of California. The state of California at best is a legal fiction or a corporation or both. And I don't see how I could be in a legal fiction or inside a corporation.
See, you're making statements, but you're making statements and you want to ask them leading questions. It's one thing to put it in the form of a question. It's another thing altogether to do it as an assertion, because one keeps the burden of proof on them, the other puts it on you. So I think it's better to ask, excuse me, but sir, aren't you just aren't you just repeating the prosecutor's claim? No one is contesting that I was physically in California. Is it your position that my physical presence in California, not the state, please just use, lay terms, sir, Is it your position that just because I'm physically in California, a written instrument called the Constitution applies to me? Yes or no? Because then you can ask him a follow-up question. Exactly how would does my physical presence prove the Constitution applies to me? How does that, please explain that to me, and I'll plead guilty right now.
Yeah. And a couple of settlement hearings ago, or last, I think in the May settlement hearing, I asked him under what authority and what jurisdiction does the prosecutor have to even bring this complaint? And he said it's personam jurisdiction, but he just keeps changing. I don't think he knows the law. He's a new commissioner, like sworn in back in March. And I think he's just doing his thing because he probably used to be a prosecutor. So he's just assuming that he really doesn't clearly understand laws and this stuff and what complaints are and verified. But anyway, he ended up entering a plea for me yesterday because he just, once again, declined everything I brought up, like corpus delicti and everything else again.
But that's because you're doing it as assertions. You're doing it as assertions more than asking the questions. Did you object to him did you have the unsigned plea of guilty? Did you tell them that you intended on pleading guilty?
Yes, I said I will plead. I fully will plead guilty right now to these charges if you can actually show me evidence and facts in the court record that prove that you have jurisdiction over me and that there is an injured party giving the jurisdiction. I need to see proof and evidence of one of these, and I need someone to see someone get up on the stand and swear under penalty of perjury that these codes even apply and that I actually caused somebody harm. And he just kept blowing up. I'm going to enter a plea. And so when he said a not guilty plea, I said, objection. It's my constitutional right to enter my own plea or my counsel. And
you're killing me, Eric. You're killing me.
So then,
but but Eric, hold on. We'll go a bit longer. Wouldn't it have been more effective to say objection? Are you under the impression I'm refusing to plea?
This commissioner really doesn't care about any motion I put in. He lumps all the points into, hey, we already saw this stuff from you last time, and we already declined it 2 times ago. And the prosecution, they change the DA every time. There's a different kid in there every time I go in.
Well, that's fairly that could be standard in very highly populated areas. I wouldn't fault them necessarily for that. It makes it easier for you because they're not going to be as prepared. But even if he's going to ignore that, you should still make the objection, because then you can go back and enter a motion to change the judge or disqualify the judge on the grounds of extreme bias. Like, he's so biased against you, he will actually misrepresent the record to justify pleading not guilty, because he can only plead not guilty for you if you're refusing to plea. So he could refuse to answer the question. Sir, you under the impression and you could say, objection, I am not refusing to plea. Let the record reflect that the judge is mischaracterizing the record. I am absolutely not refusing to plea. And he might still just do it anyway. They don't care. Yeah. But at least you're establishing facts to use against him.
This guy just thinks he's the king of the court and king of the land, and whatever he feels he wants to call jurisdiction, he just changes it constantly. He sounds like an idiot. But anyway, I have a trial date set for September 10th. I pushed it way out to give me time to figure out if I'm going to file claims or misconduct or other stuff. But we have jury selection on September 5th. And I read through your questions on how to cross-examine cops and stuff like that a little bit. But at this point, with the mess I'm in, what do you recommend I do in the next week or two? Should I file affidavits that I'm sure they're not going to respond to, because they won't respond to anything in writing?
But you don't respond to an affidavit. The only response you need to an affidavit is if it is valid, a valid affidavit, and just lays out facts that you have personal knowledge of, then then you may have to at trial. The prosecution may be in a position where they have to respond to those facts, but they don't have to respond to anything other than facts that are in that affidavit. So what I would do is I would file a motion to change the judge because you could then use that if they deny that, and you're going to have solid grounds because he entered a plea over your objection. He entered a plea and falsified the record that you were not refusing to plea. You stated clearly you intended on pleading guilty. Because if he denies that, then you would at least have grounds, pretty solid grounds, for a petition for writ of mandate to get the trial stopped next month. Well, actually September, in 2 months. You can stop the trial and have the denial reviewed in the higher court.
Okay. So do I do a motion to switch the judge first, or a writ of mandate?
You're going to start off with a motion to disqualify the judge on the grounds that you cannot get a fair trial from him because he's not holding the prosecution to their burden and is lying on behalf of the prosecution. Or you could say misrepresenting the facts or in the record. Your evidence to show that is what has happened so far. So the big one is going to be you were not, the facts are clear. The facts are you were not refusing to plea. That contradicts the judge's entering a plea of not guilty for you. He doesn't get to enter a plea of not guilty because he's tired of you raising questions and objections. He can only enter a plea if you're refusing. And that's not what happened. And then if that is denied, if they don't assign, if he doesn't disqualify himself, then you can file a petition for writ of mandate to review that denial into the higher court.
Okay. So I should do that right away. He's not a judge. Should I refer to him as a commissioner? Because there's a difference between a real judge and a commissioner.
Sure. You can refer to him as commissioner. It's not a big deal. So, but that's what I would do.
Do I demand a real judge, or do I call it a justice of the peace?
It's either a justice of the peace, or you just want a judge who's going to be fair and impartial and will hold the prosecution to their burden of proof. That's all you want. Whatever they're called, to call him your highness, call him, a king. Who cares, as long as the guy can act fairly to some degree? Because if he's fair to even the slightest degree, you're going to do pretty well.
Okay.
All right.
And then as far as the trial, I guess they're probably going to deny this motion because I'm going to send it to him and he's just going to deny it and say it's not timely. That's the other thing. He says everything's untimely.
No, if he says, I got to let you go on this because we're getting lined up with calls. If he does turn around and deny it for whatever reason, go straight into the higher court on a petition for a writ of mandate with a motion to stay the trial court proceedings so that the higher court can stop the trial. So
okay.
However he denies it, you can appeal the denial and get review.
Okay, great. Sorry to keep you so long. Thanks for the advice.
Not a problem. I appreciate the call. Good luck, and let us know how it turns out. We've got, we'll try. I think we got this all figured out. We've got area code 303. What's your name? Where are you calling from?
Hey, Mark, I'd like to join in if I can.
Yeah, sure. What's your name? Where are you calling from?
My name is Upendra. I'm calling from Colorado.
Ben from Colorado. What do you have for us today?
Okay, so I got a speeding ticket, and I have an arraignment coming up on July 26th. And so far, I used your motion to dismiss and your motion for discovery, which were both denied without any rationale so far.
Okay. When was that done?
Well, the first time I submitted it in June, I think it was.
And the prosecutor never responded?
They just they sent back the motion for discovery, saying citing Colorado Traffic Rules 8A and B, and I looked those up, and it does not seem pertinent to anything in the motion for discovery.
Well, yeah, the motion for the discovery request, the Brady request, is designed. We know in advance they can't be 100% compliant with that without throwing out the case or giving you the information necessary to stop the trial, which would be that their witnesses don't have personal firsthand knowledge the laws apply. So they don't have personal knowledge, the laws are violated. You know, I mean, doesn't it stand to reason that to have personal knowledge, the laws are violated, you have to have personal knowledge, the laws apply in the first place?
Right.
Makes, yeah, logical. Okay, so all right, so have you had a pretrial for this yet?
No, the arraignment is coming up on July 26th, but I was thinking of going in this Monday.
And this is just traffic?
Yeah, speeding ticket, just traffic.
Speeding. Well, yeah, you probably could take care of that by going in a little ahead of time there, but you could, if you're able to speak to the prosecutor before that and find out and say, look, I got your discovery. I don't think this is complete. I need a confirmation from you that either your witnesses do or do not have personal knowledge of what they're testifying to, specifically that the laws apply and I violated them.
So the arraignment, I can make this, or
you certainly can. I mean, you have the motion to you can refile the motion to dismiss, or you can still argue that again. You can go in with the unsigned plea of guilty, and still state that you're willing to plead or you intend on pleading guilty. Has the prosecution met their prima facie burden, or have they met their burden in proving personal and subject matter jurisdiction?
Right.
So you can still discuss that there, even though the judge has already denied the motion to dismiss. I mean,
and they also denied the motion. The motion to dismiss, but there was no justification, no notes, no nothing. It just says denied.
Right, and that's something you can question him on. So one of the things I like to ask him, because the motion to dismiss is based on lack of evidence, to deny it, the judge would have to be convinced there was sufficient evidence. Well, sir, your motion is lacks merit because they do have sufficient evidence. So that's why I would ask him, is it your position that the prosecution has submitted sufficient facts to prove that just because I'm physically in Colorado, the Constitution applies to me? And then take it from there. The only thing he's going to do, like what happened with Eric in Los Angeles, is going to be able to point out the ticket. But I've done this before, and many of us have done, many others have done this. If we are able to get dialogue on it and say, what on this ticket? Are you saying my physical location? What on this ticket proves the Constitution applies to me? Almost 100% of the time, the judges have reversed themselves. Now, they still didn't do the honest thing. They just backed off their previous statement that the ticket was evidence of jurisdiction, when it obviously is not. If the ticket was obvious, look, if a ticket or complaint was evidence of jurisdiction, then we could file against the prosecutor and the judge, right? And the ticket itself is evidence of jurisdiction.
Right. It makes sense.
Yeah.
But how can we get these guys to actually comply? Because it seems like they're just ignoring everything we're doing, and we keep filing motions, talking to them, and it's just ignore down the line.
We can't get them to do the right thing. We can't force them. I mean, like I mentioned with Eric, you could possibly maintain a petition for writ of mandamus to get to stop the trial and ultimately get the judge to recuse himself. There are things, but you also have a petition for writ of prohibition. So if the motion to dismiss is denied without explanation, there's nothing in the record to prove jurisdiction, then you can file a petition for a writ. But those are very, very difficult to maintain. They don't like to take jurisdiction over those. So ultimately, there's nothing we can do. The only way that you could get it stopped is if you have a jury, which you're not going to have here. So for others listening, if we have a jury and we can reach one person in that jury, that one person can hang the jury and prevent the judge from convicting you. But other than an appeal or petition for a writ, yeah. All we can do is be professional, object, and make it as difficult as possible for the judge to make it look good. And that's probably, the biggest reason why we get these things tossed out, is because they just can't make it look good anymore.
Also, I had called them up and asked if I can get some cameras going in the courtroom, and they completely rejected that. They just said that it doesn't like it.
Well, find out if they're doing a recording on their own, because something came up a couple times this week where the trial court was, it was traffic. They weren't keeping even an audio record. So if they're not going to keep an audio record, you should be permitted to do that. So you could put in a formal motion for at least an audio recording so that you can have a transcript if you have to appeal it. Because if there's not going to be a record and you do appeal it, more than likely they'll just order a new trial because they don't have a transcript to go by.
Okay. So my next play was just to use this. I have the signed plea of guilty.
Unsigned.
And I was going to go.
Unsigned.
Oh, unsigned. Sorry.
You're only going to sign it if they throw you a smoking deal.
Okay.
So when you present it to them, it's unsigned.
I was going to hand it to them in the court, right?
Yeah, you can. Yeah, because if what happens with like what happened with Eric, if the judge ignores the issue and enters a plea of not guilty for you, you now have documentary proof to contradict the judge that you were refusing to plea.
So one thing I wanted to point out in Colorado, it appears from the statute that it almost says that the court, like if the court thinks you did not enter an acceptable plea, they don't have to accept it. I was looking at one of the statutes. It was kind of weird.
Yeah, but the thing is here, you're not even getting a chance to sign the plea necessarily. What you're doing is you're throwing a monkey wrench in the works to try to stop the judge from just arbitrarily proceeding without holding the prosecution to any of their, to their burden of proof. Jurisdiction is a mixed question of law and fact. You don't settle that by going and looking at a Supreme Court case or a court case from, an opinion from 5, 10, 15, or 100 years ago. The prosecution has to have the evidence, not the law library.
Oh, I see.
All right. So I got to let you go because we're running out of time and I'm getting a full boat of calls. But that should be, if you have any other questions, contact me off air and you're welcome to call the Saturday broadcast.
Okay. Thank you, Mark.
Appreciate the call. Ben in Colorado. We got another new caller, area code 682. You're live on the No State Project. What's your name? Where you calling from?
Hi, Mark. My name is Parker. I'm calling from Texas, and I actually have a couple of questions. Well, let me start with what the way that I'm going about it is. I was gonna go in and, of course, have questions for the judge. I was gonna ask him if it's civil or criminal, and obviously he's gonna say criminal there, or I could just dismiss it for no injured party. And then if to go further into that, is it a common law or is it a military tribunal like an admiralty? And when he answers that, I could dismiss or just say my reasons for dismissal. Like if he was to say it was a military tribunal, he doesn't have the right to use.
No, come on, no, Parker. This thing I just went through this with Eric. I wouldn't bother with any of that stuff. We know what the basis of their perceived jurisdiction is. They believe that you're physically in Texas, and that means that a written instrument from 1836 magically applies to you. No evidence other than your physical location. And they'll say stupid things like this to you. Parker, jurisdiction's a pure issue of law. It requires no evidence except for your physical location. So, pregnant, not pregnant. So I would stick with just the claims that they're actually making. Keep the burden of proof on them. You start coming in with this stuff and they're going to label you a sovereign citizen Freeman type, and they're just going to shut down.
Huh. Okay. So, I've read through your script and you think you just stick, obviously it's your script, you wrote it, but another problem that I had that you also touched on with the last caller is that my court is not a court of record that I'm going to be going into in about a week or 2 weeks or whatever. So, is there a way that I can try to get a trial in a court of record, or do I need to record? You were just talking about recording it yourself.
The only other, I think if you lose and you file, you appeal it and they order a trial de novo or a new trial, then you will be in the the higher court or the county court, and that will be a court of, a court of record. You could find out in advance if they're recording it, and if they're not going to be recording it, you have to put in. Unfortunately,
I asked them, and they said they weren't. Like they've already told me that they weren't. Like there's no, which I think is crazy to have in a courtroom. But
sure. Well, hey, these guys do literally whatever the hell they feel like. I've had judges turn around and say there's no right of cross-examination in traffic. I mean, it's complete nonsense. I mean, even my worst critic would disagree with that. I mean, but they get away with it because there's no record. So you can either go and hire a court reporter, which is going to cost you. Well, either way, it's going to cost you, but it'd probably be less to have a transcript made from a recording that you make. Unfortunately, you're going to have to get permission to do that.
Okay. Well, those are just the questions that I had for you. I guess I'm going to go study the script a little bit. Another thing that I wanted to ask is I've been trying to join the Skype group for a while. So if you could let me into the Skype group to practice what I would say, that'd be great.
Just get me a Frank Rizzo 3 and I'll put you in the new chat.
All right. Yes, sir. Thank you for your help and all the information you give to us.
You're welcome. Before you go, Parker, remember the Socratic method. You're not making assertions. All you're doing is finding out what, you're asking leading questions. You're asking them, what is your position? And you're going through why they believe. So what is your position? And then you're asking why they believe that's true. And then you're going to get to the how. So that's the general way we're doing it. If you follow that and you're just asking questions and having them clarify, you're going to be a lot more effective than going in and asking these things about admiralty and common law and then making assertions based on that. All right.
All right. Sounds good. And you, on the last caller as well, you said that you had a Saturday show. I wasn't aware of a Saturday show.
Yeah, you can get that you can get the information at markstevens.net. I do the Liberty Radio Network, the LRN.FM broadcast from 1 to 4 Pacific time, or I guess 3 to 5 Central time. And all the information is right there on the website.
All righty. Well, I'm going to do a little bit more studying, and I might call in on Saturday.
Sounds good. Appreciate the call, Parker. My name's Mark Stevens. I'm not ending the show, so I don't know why, but we'll see what we could do. We got 12 minutes left, and we got 2 more callers. We have area code 832. What's your name? Where you calling from?
How you doing? My name is Zoe. Calling from Houston, Texas.
What can I do for you today, Zoe?
I just want to say thanks for all your work you've done. I utilized some of your paperwork, and I had a court date just passed recently. Just want to talk about it and see what you think about the things that I did.
Sure.
The first thing that I did was I put in a plea of non-assumption, saying that I have no contract with the state. Second thing I did was... Hold on.
What, Joe? Why did you do that? Was the prosecution making any had they made any claims that they were trying to contract with you? Was there any evidence that they were trying to contract with you?
Well, because they're going off of assumptions, I'm going to go also rebut all the assumptions they might think that I have with them, whether I have it or not. I just did it just as a precautionary issue. Just because, I mean, if the paperwork is wrong, then, I mean, it wouldn't hurt.
Yeah, it can.
And if it was right, then that's what I went about.
But it actually can hurt you because they can label you a sovereign citizen and they're considered by the government to be domestic terrorist. So I believe it very well can hurt you. I understand why you're doing it. I just wouldn't do that. I would stick to what they're actually accusing you because we've been able to show over the years, we got plenty of evidence to show that it's sufficient just to challenge the arguments or the claims that they're actually making.
I did that too. I just did it on top of that as well. I also did because what I noticed is that they were always, from listening to you, they would always speak for the so-called defendant. So what I did was I made a certificate of termination, terminating anybody who would speak for me or who alludes to say that they can speak for me without my authority or approval. And when I took that into court, just those two documents, and still speaking the same issue that you were speaking to, if I'm physically here in Texas, how does the laws apply to me? And actually, it seemed to go pretty well, but the judge did let me speak, let me put my motion in and everything. But the only thing that I'm a little bit concerned is that even though they wanted to move forward to trial, I refused to sign. After I refused to sign, they were kind of pressuring me to sign to move to trial, or they were taking me in, and I really didn't sign at all. Because again, I was still under the assumption there was a contract. But after that, he pushed it and set a trial date anyway.
Sure, because it's not based on a contract, though. Because none of this is based on your consent. None of it.
All right.
I mean, I had this prosecutor Hollister try to use that against somebody to try to make it look like he was a sovereign citizen because he stated on the ticket it was on a threat to arrest and coercion, and that he was participating on the threat to arrest and coercion. I'm like, wait a minute. If he didn't sign the ticket, and this is California, by the way, if he didn't sign the ticket, he'd have gone to jail. If he didn't participate in the trial, from arraignment through to conviction, if he didn't participate in that, he would go to jail. You have a failure to appear. They would issue a warrant for your arrest. The man put a statement of fact down, and this lawyer tried to use that against him and smear him. Like, what part of threat, duress, and coercion do you not understand? And I think, so my position is, look, if you've got a problem with the overt violence of the system that you are part of, then you need to examine that with the people you work with. You don't to lie on and try to smear someone who's not accused of hurting anybody in a pleading. That's immoral, and it's certainly an ethical violation even under their code.
Yeah.
So all right, I'm trying to get through quick. All right, so what else do we have here?
All right, go. Well, I just did that. And one funny thing before I go, the judge actually listened to me, and he was asking the prosecutor, is there a contract? And he was kind of banging him over the head saying, is there a contract? And there's a contract. Asking the prosecutor this, the prosecutor, was stumbling over his words, and he ended up saying no. And the judge was like, well, there's no contract. And then he's like, what do you want to do? I said, I want to dismiss. He's like, no, we're going to go to trial anyway.
Well, because it's not based on a contract. I'm really surprised the judge put the prosecutor on the spot for that. So it sounds like he got a fairly decent judge, unless he was just trying to humor you.
Right.
Which I don't see that happening too often, not at this level.
Well,
so
I have court just coming up Tuesday. So I'll call in and let you know what the verdict is.
Well, you got to do some role playing. You got to get a script or do some role playing. Get on the No State Project Skype chat. I'm Frank Rizzo 3. I'll put you in there. Spend a few hours doing that. It's going to help. You should have been doing this for the last few weeks, but like I mentioned before to some other callers, the principles are what's important. You're holding them to their burden. The burden of proof is on the prosecutor, the one making the claim. Don't make assumptions. Ask them leading questions, which means that the information you're trying to elicit is in the question. So that is going to be huge. And assume that every single thing the prosecutor, the judge, and the cop are saying are lies. You make your objection and you ask questions to get them to verify what they said. All right.
Will do. Thank you for your time.
Appreciate the call. Good luck at Zoe in Houston. And we'll go to our last caller. I'm thinking this is New York, but I may not be correct there because, cell phones. But we got area code 315. What's your name? Where you calling from?
I'm Eddie, and I'm calling from New York. I've talked to you a few times over the years. It's been a few years since I spoke with you.
Oh, okay. Well, what do you got for us, Eddie?
Well, so you don't have a lot of time. I'll probably bring it up on Saturday, but I got a transcript of an arraignment before they took it to a grand jury.
Oh.
And I think I should copy it for you and send it because some of the things that you talk about, I want to, and when he was being arraigned, and he challenged the jurisdiction, a couple times I've heard you say that where you can't be within the state because it just exists on paper.
Well, the state is a body corporate. The state only exists on paper in that it's a body corporate and a body politic. And that the prosecution, when they claim to represent the state, they're not claiming to represent the physical area of New York. They're representing what they believe is the body politic and the body corporate.
Oh, well, with that being said, he acquired the what is it? Your dismissal script, the challenge jurisdiction. I think it was the dismiss for lack of jurisdiction script.
Okay.
And they tried to say that there was no facts in the script, and the district attorney used. Well, the main district attorney stepped in for the assistant because the assistant wasn't handling it properly like they would want. So he stepped in and started using the fact that he used his address on the document, on the dismissal document, as proof that they had jurisdiction.
All right, say that again. What did they use as proof of jurisdiction?
The fact that he put his address on the dismissal. It said and I'm gonna quote. And the guy brought up the fact that he didn't bring up the motion to dismiss, and the judge responded that that's a legal issue, so the grand jury doesn't get to decide it. But what I'm talking about is the district attorney says, and I quote, "He's also present in the state. Based on his motion that was filed, he lists his own address as in such and such New York." You know what I'm saying? He is domiciled in the state, and therefore he's subject to the laws. That was what a district attorney said in the minutes.
Yeah, now the indictment? This is pretty serious. What can you tell me the nature of the charge?
It was a drunk driving.
They're indicting him for a drunk driver, for DUI.
He was pulled over for not having his trailer hooked up. The lights wasn't on. While that happened, they asked him if he had a drink, and he said he had like a beer like 2 hours before. They pulled him out. I think he blew like a .08 or something like that, and they arrested him.
Well,
for DUI, but he had 10 years and 6 months ago.
So maybe it's considered aggravated. Yeah, I guess it's aggravated, and that makes it a felony in the indictment. Holy crap!
Right.
Well, first I got to say, shame on your friend for doing something like that. I mean, a .08 is okay. And I'll say it again. I just lost a friend of mine last week. He still lived back on Long Island. He basically drank himself to death. So for those listening, watching, please do yourself a favor. Even if you are an incorrigible scumbag, please think of your friends and your family, people who may actually care about you, because the void that you leave when you're gone is horrific. I feel so bad for his family. I mean, I'm over the initial shock here, Eddie, but still, I knew this guy for 30 years. So, anyway, all right. So, well, I don't know if you're necessarily going to be able to use that transcript in, you don't get to say what is going to be presented to the grand jury. Only the prosecutor presents. So it may be something that could be used later. I would certainly would attack that. Did.
After the arraignment, instead of giving a date, they told him to go meet with the district attorney and the former district attorney outside of court. So this is 2 weeks later. He sits down with them, and they offer him a misdemeanor instead of a felony for a cop out there, which holds 8 months. And if he goes to jail for 8 months, he said he was going to lose everything that he had. So, and where he's at right now is preparing for trial.
Does he have a lawyer?
No, he's representing himself.
Oh man, this is a bad one to.
He's got every question that you asked. He asked them,
and that's great. It's just that this is a rough one to cut your teeth on. He's looking at some serious time. Maybe what he can do is he can speak with the prosecutor, because he should have. It's a felony. He should have a full blown pretrial procedure there in conference, and hold it, do what he can to hold him to his burden and let him see that, prosecuting is gonna, I'm gonna fight for my life here. So maybe we can look at a better deal here. Maybe we can look at a deal after you've been able to show that the prosecution doesn't have any evidence, is making things like, well, evidence is a trial issue and stupid things like that. And you can say, look, maybe we can, you can offer me a deal where there's just probation and there's no jail time and a fine.
Right. That's what I was trying to explain to him. Maybe he could negotiate with him, but he already sat down with them and they offered him a misdemeanor instead of the felony.
Well, so you know that they're willing to deal. What I'm saying is maybe meet with them again, ask them the questions, and like I did with this prosecutor in Arizona yesterday, and put their, in a sense, put them in a corner, put up or shut up. Where is the proof? And we'll plead, so when they can't provide that proof, when they can't provide the name of a witness or personal knowledge, it to me, that's leverage over the, for them. All right, we know you can't prove this. We know you can't prove that. However, if you can give me a misdemeanor with no jail time, I'm willing to plead guilty right now and see what they say. So that's the next step that I would take.
All right.
Well, I mean, I'd file the motion.
I'll call you back on Saturday.
Okay. I'd file the motion. Yeah.
I will get.
Well, I'd still file the motion to dismiss and the Brady request, though, because I would do that before meeting with the prosecutor. But I would meet with the prosecutor, prior to a pretrial conference if possible. And
can you file the motion to dismiss twice?
You can have it reconsidered since there's no evidence on the record to overcome the motion.
Okay.
Now,
how do you do that? By what? Putting on that document that to have it reconsidered, or just refile it for that? No,
I don't. I actually I title it motion, a motion to reconsider denial of motion, and then I just briefly show. It's very short that the motion to dismiss was based on a lack of evidence, and yet there's nothing in the record that the prosecution presented to overcome the motion. It doesn't appear in the record.
Right. Okay. All right.
All right. Well, and let me know Saturday what you hear.
I definitely will.
All right. Appreciate the call.
And I'll get you these documents so you can see them.
Yeah, I'd like to. Yeah, I'd definitely like to see that. Appreciate the call. Thanks a lot, Eddie. We'll talk to you again soon. Wow. That went pretty damn fast, as it usually does here on the No State Project. Wow. That is really bad. DUI felony. I feel, that's the thing. You're already behind. It's bad enough with just a code violation, but when you have something like a DUI where you have put people in danger, that really is. So that's why most of the time it's just getting a better deal, and it's about damage control. So Tom had mentioned something about damage control. Good friend of mine in Minnesota did some good damage control today, considered weighing, it was traffic. They wanted $400 and would have spent probably half the day there. He spoke with the prosecutor, and the prosecutor said, look, we'll give you $175 and a year probation where you don't get into any more trouble. He said, no, why don't we do this? Why don't we do $75 and only, let's say, 4 months? And the prosecutor went with it. So that was good. He wasn't doing it as an activist, but he was doing it as a matter of principle. So he did limit the damage that they were trying to do. So even the prosecutor's question, like $75, that just covers the court cost. There's no, I'm not paying a fine. I'll give you $75, and he walked out with that. So that was a good job. A good job. But this has been the No State Project for July 11, 2018, commercial free. I will not have another video. This is it. I'm not going to be pulling this live stream down, so all the comments will still be there. I was out of town till late last night, didn't get everything set up. But hey, one minor tech issue, so not too bad. I see where right before I end the show, I got to get this crap. But yeah, we'll be back on a Saturday broadcast. So if you're looking to learn how to effectively defend yourself against these criminals, and yes, I say that they are criminals, and my evidence is when you force strangers to give you money, you are a criminal. Okay? None of these services that we actually want, and the big problem that anarchists, at least me and those I know, the problem that we have with these people called government is the fact that the services are provided on a compulsory get shot or go to jail kind of basis. So if all we did if the only thing we did was change so that the payment and support was not compulsory, boy, that would be some serious social evolution, and things would change quite a bit. But we could talk about that more on the Saturday broadcast. You can join me there from 1 to 4 Pacific time, right here on my YouTube channel and on LRN.FM. So till next time, salud.